Hello, everyone, and welcome to our podcast. Today, we will discuss the concept of incorporation of an arbitral clause by reference to another contract. This has emerged to be a significant topic in commercial law as well as in dispute resolution. I'm Nishanth, and I lead our international disputes practice in our Bangalore office. And with me are our co-hosts Soumya and Ansh, who are based in our Bombay office. So Soumya and Ansh, to start with, could one of you explain the concept of incorporating arbitral clauses by reference in commercial transactions?
Certainly, Nishanth. In contemporary business landscapes, transactions often involve an intricate network of interwoven sub-transactions. Now, these transactions involve multiple stakeholders entering into multiple agreements, each contributing to a collective commercial objective. Some agreements may have detailed provisions including dispute resolution mechanisms, while others may address specific points and seek to incorporate other provisions from earlier agreements. When a dispute arises, a critical question is whether the dispute resolution clause in an earlier agreement will apply to disputes under the later agreement.
Thanks, Soumya. I can see how this can be a complicated question, given how arbitration is a consent-based mechanism. Ansh, what is the Indian position on this issue? Have there been any court cases that have dealt with this?
So, Nishanth, Section 7, Clause 5 of the Arbitration and the Conciliation Act 1996 allows incorporation of an arbitration clause by reference and states that the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference is such as to make that arbitration clause part of the contract. In the MR Engineers case, the Supreme Court of India dealt with this interpretation of Section 7.5 of the Arbitration and Conciliation Act 1996. The court laid down several principles, such as an arbitration clause can be incorporated by reference if there is a clear mention of the document containing the clause, an intention to incorporate the clause, and the clause can be applied to the dispute. A general reference to another contract is not enough. The arbitration clause must be specifically mentioned. If a contract stipulates adherence to another contract's terms regarding performance and execution, it doesn't automatically include the arbitration clause unless specified. If the contract states that the conditions of a trade or professional institution will apply, including arbitration provisions, they will be considered to be incorporated. If a contract includes the conditions of one party, the arbitration clause in those conditions will apply.
That's very comprehensive, Ansh. Thank you.
To add to this, Nishanth, in fact, in the Inox Wind Limited versus Thermocables Limited case, the Supreme Court analyzed the position under the English law, referring to Sea Trade Maritime Corporation versus Hellenic Mutual War Risks Association Bermuda Limited, the Athena. The Supreme Court explained the difference between incorporation by reference in a single contract case and a two-contract case. If the parties to the document being referred to are the same, it is considered a single contract case. If at least one of the parties is different, it is a two-contract case.
That's interesting. So how did this distinction impact the Supreme Court's decision in the Inox case?
So the court noted that after the decision in MR Engineers, the law developed further with the English courts, expanding the single contract principle to include even standard form contracts and standard terms and conditions of one of the parties. In Inox, the Supreme Court held that an arbitration clause contained in a party's standard terms and conditions, attached and generally referred to in a purchase order, would apply to even disputes under the purchase order.
That's very interesting, Soumya, and I think that sort of evolves the Indian position further after the principles laid down in MR engineering, while not deviating from it too much. But I think this case was decided in the year 2018, has the position largely remained the same, or have there been any other developments?
In a recent decision rendered in March 2024, the Supreme Court in NBCC versus Zillion followed principles laid down in MR Engineers and Inox Civils, and it was reiterated that a clear and specific reference to an arbitration clause is necessary for its incorporation. In NBCC, the contract under which disputes arose actually specified that disputes would be resolved by the courts in Delhi, whereas the standard terms refer to contain an arbitration clause. So the standard terms were of a third party, which is the main contractor, and not of the parties to the dispute. Due to this, the court held that the parties did not intend to incorporate the arbitration clause in the standard terms into their contract.
Thanks, Soumya. And this case, I believe, is very recent, so the position remains largely unaltered. Now, we've gone through what the Indian Arbitration Act talks about incorporation of arbitration clause by reference, and also how Indian Supreme Court judgments have dealt with it. Now, let's compare this position to few other jurisdictions in Asia. Is it largely similar to the approach in India as per the principles laid down in the cases we just discussed, or are there any variations?
So different jurisdictions in Asia have different approaches. In Singapore, for instance, the Court of Appeal in International Research Corp PLC versus Lufthansa Systems Asia Pacific Pte Limited emphasized the importance of the parties' intention and the context. The key consideration is whether the parties intended to incorporate the arbitration clause based on the surrounding circumstances. And as opposed to this, the English position, opposed to the English position, even in a two-contract case, if on a contextual interpretation it is found that the parties did in fact intend to incorporate an arbitral clause, such clause would be valid and effective.
Thanks, Soumya. And what about, so Singapore is, as we all know, a very important jurisdiction to keep in mind, especially for commercial transactions. What about some other Asian jurisdictions, say, for instance, Hong Kong?
In Hong Kong, the courts have taken a similar approach. In Astel Pinegar joint venture versus Argus Engineering, the courts held that a general reference to the terms of another contract could suffice to incorporate an arbitration clause, provided the intention of the parties is clear.
Are there any jurisdictions with a more, say, stringent approach?
Yes, some jurisdictions adopt a more conservative approach. For instance, the Dubai Court of Cassation in DCC 1308 of 2020 held that a general reference to standard contract terms is not sufficient to incorporate an arbitration clause unless it is explicitly mentioned. This approach ensures that parties are clearly aware of the arbitration clause before it is deemed to be applicable.
So clearly there's a divergence in the approach adopted by, say, a Singapore court or a Hong Kong court to that of a Dubai court, which seems to be more conservative. So to summarize then, the question of whether an arbitration clause in another contract stands incorporated by reference to such a contract can be quite complex, and it varies significantly across jurisdictions. What can be the key takeaway from all of this for businesses entering into agreements that may involve incorporation of clauses from other agreements?
The key takeaway is to avoid ambiguity by clearly stating whether an arbitration clause from a referenced contract is incorporated. This clarity can prevent future disputes and ensure a smoother dispute resolution process.
Thank you for that detailed insights, Soumya and Ansh. This concludes our discussion for today. We hope our listeners found this episode informative. Thank you very much.